Judge Appeal on that stance. So then will remain in the work rules. Okay, anything further from the defense? Okay, and I believe the media press asked to do something. I wasn't quite clear on what I was being asked. So somebody could first announce who you are and then make your request.
Hi, yes. Brendan Ponton from WTKR Channel 3. We were asking if we could put a second microphone on the witness stand just so we could be able to clearly hear what people were saying.
Okay, this will be a wireless or wired mic?
Wireless.
Wireless, okay. And we'll turn it off when we're not in session?
Yes.
Okay, not a problem. Yes, you may approach to do so now and then let me know when you're ready. And then while they're doing that, Chair, did all the jurors report? We have 14?
We have 14. I believe 13 news also had a question.
Oh, we have another, okay, while he's doing that, okay, yes, ma'am, and state your name.
Yeah, Madison Schlegel with 13 News Now, Your Honor. Obviously, we're on a 30-minute delay with how you would like us to go about redacting the feed if something does slip or if something is mentioned. Would you prefer us to just stop the feed altogether? Would you prefer us to mute it? Unfortunately, after it airs in that 30-minute period, we don't have access to edit that video. So technically in-house, we can't physically redact something in that 30-minute delay, if that makes sense.
Oh, and I'm not familiar with how the technicalities of media work. So, you know, I see that as a layperson. Do you bleep it? Do you blur it? What are the options?
Yeah, so unfortunately, in that 30-minute window, we don't have the capability to grab that video and bleep something or blur something.
So you could just stop and just not air that portion?
Yeah, we would have to stop the stream then for that 30-minute period until that 30-minute period would essentially air, if that makes sense.
I mean, if you're telling me that's your only recourse.
Yeah, I mean, if you guys have any other. Okay, cool. Yeah, I mean, that's the only way that I kind of see it working out. I just wanted to, again, confirm with you.
So,
before
if a
we
minor's name is stated, and it should not be stated and released to the press by statute, you can't just mute that. You would just have to
stop the stream.
stop the stream.
Yes.
Okay, if that's your recourse, please do so, but you have to comply with the statute.
Of course, yes. We just wanted to be communicative with you to make sure that that was okay.
Okay, thank you very much, Ms.
Yes,
Michael.
of
I
course, thank
understand. All right, anything else from the press? All right, yes, please stand up and state your name.
I'm Chris Horn from Lake TV. I was wondering if Your Honor could grant a 3 or 4 day excuse for telephones for media. Muted.
Okay, so I don't know how many are media and muted. I have granted that request from Mr. Dujardin with the Daily Press, and he made that in writing prior to the trial commencing. Who else is asking? I need to know, the sheriff needs to know, so that when we see these cell phones, we respond appropriately.
I was going to suggest one representative from each of the channels. And
Okay.
whoever else need, I know New York Times is here. Whoever else is accredited to be.
Okay, and so my answer is yes, but I need a list of the person's name and the organization that they're representing. And again, I'm defining media by the statute definition. So these need to be accredited persons, members of the appropriate broadcasting associations. So, you know, your average blogger and blogger do not qualify. Okay, all right, but so yes, Mr. Horn, we can do something.
Compile this, give it to the bailiff.
Okay, all right. And then, bailiff, what's the best way to accommodate that when they come into the scanner in the morning? Because, you know, by the time you get here, you're past the point of entry, which is where they're gonna block cell phones.
Your Honor, I'll take it.
You'll take care of it, okay. And Deputy Hopkins is the best. I need the news to capture that. Okay. Okay, anything else from the press before we bring the jurors out? Yes, ma'am, state your name, please.
Jackson from TPAN, I'm here from Richmond, Virginia. And you just stated for your regular bloggers, the YouTube bloggers, how else will we be able to get this media?
Do you qualify as a press under the statute?
I will have to double check on that statute. I've been YouTubing for the last 3-4 years.
Okay, and so let me.
And I just want to know if there's anything to submit to the
notice that the legislature has defined it. What was my last word? Okay, and do a pen and paper?
Yes, ma'am, I do.
Okay. It's Virginia Code 19.2-271.5A. 19.2-271.5A.
Thank you.
So if you are a youth organization according to that statute, then you can bring your cell phone. If not, then you cannot.
Yes, ma'am.
All right, thank you. All right, anything else? All right, we're going to bring out the jury. We'll start with my opening instructions and then opening statements.
Your Honor, before we bring the jury out, could I step out for just a minute?
Yes.
Thank you.
We're gonna bring them out, but you step out and I won't start till you come back. Yeah, right here.
Mother Nature.
Okay, yes, thank you. Okay. That's working out.
What's that?
I said, Struthers is watching. That's what she gets. You know, Struthers is my home.
Yeah, I know.
Yeah, that's what she gets.
I ain't thinking about her.
She a big girl.
That's why I moved all her stuff. And I am gonna put it back before she get back,
Right.
you know, for my sake.
Right. I was like, I'm sorry, no more we go.
That's right. Do you have a preference on the issue?
Let me get back more books.
But
Yeah,
work
I do.
with-
Yes, after open, because that's one of the evidence, and I don't know if we're taking it. Right, we have open, that's not evidence. Yes.
Okay. All right, should be done. Please stand for the jurors. Y'all can take your seats as you come in. Jurors in the box. You may be seated.
Thank you. Good morning to everyone, but Tuesday morning to the jurors. Madam Clerk is going to take your attendance to make sure we have the correct people reporting, and then we'll get started.
When I call your number, just say here. Number 2.
Here.
Number 4.
Here.
Number 10.
Here.
Number 18.
Here.
Number 23. Here. Number 24.
Here.
Number 27.
Here.
Number 28.
Here.
Number 29.
Here.
Number 31. Here. Number 33.
Here.
Number 35.
Here.
Number 37.
Here.
Number 38.
Here.
Thank you very much. As we told yesterday with the reminder not to discuss this case, research this case, I just want to make sure that we all abide by that. Are there anything or any issues that anyone needs to report? Okay, wonderful. And again, we see all the camera and media here today, but I want to assure you, you all will not be recorded, nor your faces, nor your names released to the press and to the internet and to the world. So I just want to give you that assurance. So today we're going to start. I'm going to give you some instructions, and then the attorneys are going to have opening statements. So the order of the trial is in 4 stages. There are opening statements, presentation of the evidence, instructions of law, and final argument, closing arguments. And so first, the Commonwealth's attorney may make an opening statement outlining their case. The defendant's attorneys may also make an opening statement outlining their case. In their opening statements, the lawyers will tell you what they expect the evidence to be. This should help you understand the evidence as it is presented later through the witnesses, and to make you aware of any conflicts or differences that might arise in the testimony. What the lawyers say in opening statements is not evidence, and you must not consider it as evidence. Neither attorney is required to make an opening statement. After opening statements, the Commonwealth will introduce evidence, and at the conclusion of the Commonwealth's case, the defendant has the right to introduce evidence. When the defendant rests their case, the Commonwealth may introduce rebuttal evidence. At the conclusion of all the evidence, I will give further instructions on the law, which is to be applied in this specific case. After which, the lawyers will make their closing arguments. In their closing arguments, the lawyers will refer to testimony and other evidence that you have heard. But again, what they say in closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as the jurors as of what the evidence in the case is, which governs your deliberations. After closing arguments, you will retire, select a presiding juror, which is what we call the foreperson, deliberate, and arrive at your verdict. You must not be influenced in any degree by any personal feelings of sympathy for or bias against any party to this case, for each party is entitled to fair and impartial consideration. The law applicable to this case will be given to you in these instructions and in other instructions I will give at the conclusion of the case. It is your duty as jurors and part of your oath as jurors that you will follow all such instructions. It is also your duty to determine the facts of this case from the evidence and reasonable inferences arising from the evidence. But in doing so, you must not engage in guesswork or speculation. The evidence that you are to consider consists of the testimony of witnesses and any exhibits entered into evidence. The admission of evidence in court is governed by rules of evidence that have been developed over the years. The purpose of the rules of evidence is to protect the fairness and the accuracy of the fact-finding process in which you are engaged. From time to time during the trial, it may be the duty of an attorney to object to what is being offered into evidence. Please do not hold it against the attorney who is making the objection. They are not trying to hide anything from you. Instead, they are simply trying to see if the rules of evidence are followed in this case. It is my duty as a judge to rule on those objections and determine whether you can consider certain evidence. Therefore, you must not consider any evidence to which I sustain an objection or which I direct you to disregard. If an objection is overruled, then you may consider that evidence together with all of the evidence in the case. It is important to keep in mind that no statement or ruling or remark or gesture that I might make during this trial is intended to indicate to you my opinion of the facts of this case. Let me give an example. My focused, concentrated face as a frame. I don't do it intentionally. So don't think I'm upset, mad, or scowling. I'm just, as kids say, locked in. Okay? So, and nothing that I do should influence your decision. You are to determine the facts of this case. In this determination, you alone decide the believability of the evidence, its weight, and its value. A good deal of evidence that you will hear in this case will be in the form of testimony and witnesses. In taking into account the weight and value that you choose to give the testimony of any witness, you may consider their attitude, appearance, and behavior, the interest of the witness in the outcome of the case, the relation of the witness to any party, the inclination of the witness to speak truthfully or not, the probability or improbability of the witness's testimony, and all other facts and circumstances and evidence. In sum, you may give the testimony of any witness just such weight and value that you determine it is entitled to receive. Until this case is submitted to you for your deliberations, it is very important that you do not discuss the case with each other, the parties, the witnesses, or any spectators, or remain within hearing of anyone who is discussing the case during any break or recess. This includes discussing the case in person, by phone, by other social media means, email, Facebook, Twitter, or any kind of website or blogging. If you are approached by anyone concerning your jury service, you should make that fact known to the sheriff or to the court. You may not go to the scene or make any independent investigation or receive any information about the case from radio, television, newspapers, or social media. Once your deliberations commence, then you must discuss the case only in the jury room when all of the jury members are present. You are to decide this case solely on the evidence presented in this courtroom and not on the basis of anything anyone who hasn't heard the evidence may think about this case. If you are asked or approached in any way about your jury service or anything about this case prior to rendering a verdict, again, you have been ordered not to discuss it, and you should report that contact to the court as soon as possible. Do not attempt at any time prior to the conclusion of this case to research any fact, issue, or law related to this case, whether by discussion with others, by research in the library or on the internet, or by any other means or source. You must not use internet maps, websites, blogs, or any other program or device to search for information about the case, the law that applies in the case, or the people involved in the case. Your sworn duty is to decide the case solely and wholly on the evidence presented in this courtroom. I will expect you to inform me if you become aware of another juror's violations of these instructions. You are to keep an open mind. Do not decide any issue in the case until it is submitted to you for your deliberations at the conclusion of all the evidence and after you have received the complete instructions of law. Just prior to your deliberations, you will be given final instructions regarding your selection of a foreperson, how to conduct deliberations, and the forms for your verdict. Regarding note-taking, if you would like to take notes during the trial, you may do so. On the other hand, you are not required to take notes. You can make your own decision about this, and if you do decide to take notes, be careful not to be so involved in the note-taking that you are distracted from the ongoing proceedings. Your notes should only be used as
here in Newport News, there was one and only one person who had both the authority to take action in a crisis and the knowledge that a crisis was underway. My name is Josh Jenkins. I am the Commonwealth's attorney assigned to prosecute this case. I'm assisted by my paralegal at counsel table, Megan May. And I thank all of you, as the judge has said, for your service. I know it is inconvenient to be a juror, but this case is important to all involved. And I thank you for doing your duty, and I know that you will. On January 6th of 2023, parents of children who went to Richneck Elementary and the children themselves woke up to a normal day. They packed lunches, got on the school bus, got in their cars. One walked to school that you'll hear from. And to them, nothing was different that day. And as the parents watched their children, backpacks in tow, walk into that building, those parents entrusted the care of those children to that school. They had a promise that when I bring my child into school, the school will keep them safe. But the evidence will show you that that's not exactly what happened. I understand, and perhaps you understand, that in this incident, a teacher was shot. That is a horrific tragedy, and I do feel for Ms. Zwerner. But this case is not about Ms. Zwerner. This case is about the children who lived through this event in Ms. Zwerner's classroom, 20 of them. That's what this case is about. You will hear from that teacher because she witnessed the events, but she is a witness. The victim of this crime are the children. The defendant are the children. The defendant, Dr. Ebony Parker, was the assistant principal at Richneck Elementary at the time. She was the person who was paid to take care of those children. And around 11:40 a.m., Ms. Zwerner had seen a particular child who you will learn has a long history. A long history of discipline issues of which Dr. Parker was already aware well before January 6th of 2023. But Ms. Zwerner observed something about this student that worried her. You're going to hear from her, and you're going to hear what that concern was. And then she's going to tell you that she went to Dr. Parker and warned her that this child, who we refer to as JT, was in a violent mood. You'll hear that she said, "I don't know what I'm going to do if he hits me." That is the knowledge that Dr. Parker had of the history of JT, that and more. But at 11:45 a.m., Ms. Zwerner walks in, tells Dr. Parker that JT is in a violent mood, and Dr. Parker does not respond to her, stares at her blankly for just a moment, and then returns to her work in her office. The warning ignored. You're going to hear that this child's past means that no warning should be ignored. Because you're going to hear from a teacher that taught JT the year before. You're going to hear about the violence that that teacher experienced at the hands of a kindergartner. And you're going to hear about the report that that teacher made to Dr. Parker in that year. And that Dr. Parker's response was blank stare, look back down, do nothing. The same response she had at 11:45 a.m. on January 6th, 2023. But that warning was not the only warning. At 12:20, a reading specialist tells Dr. Parker that she thinks maybe JT has a firearm. She says maybe it's a toy, maybe it's real, I don't know. She thinks JT has a firearm. She says, "I'm going to search his backpack." Dr. Parker really doesn't reply to her, but she goes and searches the backpack. Doesn't find anything in the backpack. Meanwhile, there are some concerning observations that are happening on the playground with JT. And you'll learn why teachers and counselors then come to expect that JT has taken that firearm out of his bag and put it into his coat and is carrying it around on a playground full of elementary age students at Richneck Elementary School. You're going to hear that he showed it to another brave student, who then reported, young RR reported exactly what he had seen to a teacher. He was terrified, understandably shaken, crying when he reported what he'd seen. At 12:30, that reading specialist goes back to Dr. Parker and says, I think he has the gun in his jacket. Do nothing. His mom will be here soon, she says. I can only imagine how that made our feel. But around 1 p.m., a counselor goes to Dr. Parker and says, I want to search the child. Can I search him, his person? She says, no. Mom will be here soon. For over an hour, multiple people went to Dr. Parker and told her there was an armed child at an elementary school running around with, interacting with children in the classroom, children on the playground, children in the hallways. Multiple warnings brought directly to her. She says, do nothing. Does she say, search the child? No. Does she say, call the police, or does she call the police? No. Does she remove the child from the classroom and separate it? No. She didn't even get up from her desk. She didn't even leave her office. Warning after warning after warning, she did nothing. The crisis in this case did not begin with the firing of a gun. The crisis in this case began at 11:45 a.m. when Ms. Zwerner initially warned Dr. Parker that there was a problem. That was the moment Dr. Parker should have left the office and investigated what was going on. There is a moment that will be described to you by a witness on the stand, Ms. Zwerner, where after all that she now knows, all the suspicions that she's now heard, and repeatedly she's heard people that Ms. Kovac and others are going and telling Dr. Parker, she sees JT in the classroom wearing the big coat. She's nervous. And if in an instant she sees him pull out that gun and aim it directly at her face. And before she has a chance to do anything but raise her hand up, JT fires that weapon. It hits Ms. Zwerner. At the moment that he fires that weapon, there are 19 children. Right there. And that's why I tell you that this case is not about Ms. Zwerner. This case is about the 19 children whose lives were endangered in that moment, but in the moments before as well. Those children were, some of them, between the gun and Ms. Zwerner. Some of them, a slight movement of the gun could have hit a child instead of Ms. Zwerner. They're right there. Some standing shoulder to shoulder with the shooter. All of them, you'll learn, watched as their teacher clutched her chest and bled before these children, screaming in horror, ran across the hallway to another teacher's classroom. And Ms. Zwerner ran to the office and collapsed on the floor. Where, at that point, was Dr. Parker? She had locked herself down in her office. Was the school on lockdown? Not yet. Still no. But a few minutes after Ms. Zwerner enters the room, a receptionist, Ms. Oliveria, does finally put the school in lockdown. I commend her for doing that. She should have had to, and it was too little too late. Back in Miss Zwerner's classroom, Miss Kovac has shown up, the reading specialist I told you about earlier. She knows JT, she knows his history, and when she heard that gunshot, she knew exactly what happened. And she went straight into that classroom. She found in that classroom the gun lying on the floor. You'll learn that that gun contains 7 rounds, one of which, 7 rounds plus one that was jammed in the action of the firearm. So 8 that was unspent. Amy Kovac enters that room and she just puts JT in a bear hug as she calls 911. She holds that child there until police arrive. She will tell you that that whole time she was saying he was cursing. He was saying, explaining that he shot his teacher. And she was saying, like the consummate faculty teacher she is, don't use that bad language, you know better. She's just doing the best she can to control the situation alone in a classroom where a teacher has just been shot. Ms. Kovac, the reading specialist, also the one who searched the book bag after telling Dr. Parker that's what she's done. A task that I don't think reading specialists are supposed to do in an emergency. And the reason that I don't think that is because school policy at the time said exactly that. Richneck had adopted a crisis management plan. And that plan required teachers and faculty members to report crisis situations to administrators, and it required administrators to take actions. One such policy from the Newport News Handbook, you'll learn, was that in terms of searching a student, that could only be done by an administrator or a school security officer. And at the time of this shooting, there was no school security officer at this building. They shared their security officer with another building, and so the security officer was at the other school. So at the moment of this crisis, there were exactly two people in the building who had the authority under the policy to take action. And those two people were the principal, Ms. Newton, and the assistant principal, Dr. Parker. But let me remind you of how I started today. There was only one person that had both the knowledge of the ongoing crisis and the authority to act. While Ms. Newton, the principal, certainly had the authority to act, she had no idea about any of this. Because Dr. Parker, nor anyone else, bothered to tell her. Miss Newton, you'll learn, didn't get any of these suspicions that day. She didn't know any of this was happening until there was a gunshot. So she had authority, but no knowledge that there was a problem. It's only Dr. Parker that had both of those things. When you hear from these faculty members, they will tell you that they wish they had violated the policy. In hindsight, there'll be no question. They regret it. They regret following Newport News policy. They will tell you to a person that they wish they had just searched the kid and gotten the gun, or they wish they had just called the police. That's what they say in hindsight. And you know what? I would bet that Dr. Parker also wishes she had done differently. I do. But here's the difference. The policies that were in place enabled, in fact, required Dr. Parker to act. The teachers, on the other hand, and faculty, if they were to act, they'd be acting against the policies that were in place that day. And that is a significant difference. There was only one person in the school that day that had both the authority to act and the knowledge of an ongoing crisis. And that person, you'll see, was Dr. Parker. Many people knew the crisis had begun. 2 people had the authority to do something about it, but only one person had both. During the course of this trial, we are going to mention a lot of initials. We're not saying the names of the children because we don't want to put their names out there to let this be their story further. So we're asking everyone that testifies, and all of the personnel will definitely be using initials. I say that because that's going to be a lot of initials. The judge talked to you about taking notes earlier, and it is your choice. These will be distributed to those who wish to take notes here in a few moments. Let me encourage you that almost all of the important evidence in this case is going to come out piece by piece by piece, puzzle, little detail by little detail, from several witnesses who will take the stand and testify. And when you go back to deliberate at the end of all of this, all you'll have is your memory and your notes to help refresh you. You won't be able to have testimony read back to you, as the court pointed out. And often I've had the experience of jurors deciding to ask a question, which is, what did so-and-so say in their testimony? And they're always told by the judge, we can't answer that question. You have to rely on your own memory. And so I'm just giving you that heads up. We're going to be throwing a lot of initials at you, a lot of details at you. And when the judge instructs you on the law at the end of this process, you'll have to remember all those details in order to decide this case. So I do ask you to really pay attention to the witnesses, and I suggest that you take notes to help refresh your own memory, because at the end you will have heard a lot from a lot of different people. January 6, 2023, 20 students went into Ms. Zwerner's classroom, and their lives were forever changed. The trauma that they experienced is unspeakable, and you will hear from some of the parents about that trauma. That shouldn't have happened. And the one person who had both the authority and the knowledge that a crisis was ongoing is the reason that it happened. And we think at the end, the evidence will show you exactly.
But the defense like to give an opening statement.
Yes, Your Honor.
You may proceed.
May it please the court, Mr. Jenkins, ladies and gentlemen, as you found out yesterday, my name is Curtis Rogers. I, along with attorney Stephen T, are representing Dr. Ebony Parker. Ladies and gentlemen, you have heard that my client, Dr. Parker, is accused of the crime of felony child abuse and neglect. There is one thought that I want you to keep in the forefront of your mind during the pendency of this trial. And that is, based on their actions, there wasn't a gun. Based on their actions, there wasn't a gun. Now, the Commonwealth talks about a lot, and this ongoing crisis, and that Dr. Parker was the only person that had the knowledge of the crisis and the authority to act. I would submit that's not accurate. It's not true. And think about it. Who was the one person that was there from the beginning to the end? And that was the Zwerner. Okay, based on her actions, she did not act as if there was a gun present. So if she thought there was a gun present, then her actions should have been to separate the child, in this case JT, from his classmates, or separate the classmates from JT. She didn't do that. There was also another person that had suspicions, and that was Amy Kovac. Okay. If she thought that there was a gun, she had the authority to separate JT from his classmates, or initiate a separation of the classmates from JT. That did not occur. Commonwealth mentioned that JT was out on the playground with his classmates, and there were teachers, agents of the school that observed things that were going on. He said that caused them alarm, but based on their actions, they did not respond as if there was a crisis or danger to those students. They did not separate JT from his classmates. They did not separate his classmates from JT. So Commonwealth was saying that only Dr. Parker had authority. Each one of those individuals had the authority to remove those classmates or to remove JT if they thought that those students were presented with any kind of threat or harm or danger. We're at the beginning of this trial, and I need you to understand that right now, Dr. Parker stands presumed to be innocent. Right now, she's innocent. The Commonwealth has to prove beyond a reasonable doubt that she's guilty of the allegations that they are presenting. The Commonwealth has to prove that Dr. Parker was a guardian or other person responsible for the care of the alleged victims. Before Dr. Parker, there was the teacher, Ms. Zwerner. And the Commonwealth has to prove that Dr. Parker's willful act or omission in the care of the children was so gross, wanton, and culpable as to show a reckless disregard for human life. Who was the person that saw these events from beginning to end? That was the teacher, Ms. Zwerner. Who was another person that pretty much saw everything before Dr. Parker was? That was Amy Kovac, the reading specialist. There was another person that saw everything from definitely before the shots were fired, and that was Mr. Rawls. If the Commonwealth wants to accuse Dr. Parker, what about these other people that had direct contact with this child, JT? It is my belief that the Commonwealth will not be able to prove beyond a reasonable doubt that Dr. Parker is guilty of these alleged crimes. And I will be asking you at the conclusion of this trial to find Dr. Parker not guilty. Understand, I need you to always consider, based upon their actions, there was no crisis, there was no gun. Based upon their actions, there was no crisis, there was no gun.
Thank you. All right, the bailiff is going to offer you notepads, and then we're going to try to push forward with the first witness. Does anyone in your family agree? Okay. And again, you don't have to take notes, but if you'd like so, we'll distribute notepads. While they're doing that to the attorneys, we did not swear witnesses en masse, but we'll do so as they're brought onto the bench. Is that acceptable?
Yes, it is.
Okay. And is there a motion regarding witnesses?
Motion to separate. We agree.
Okay, so ordered. And I'll allow the attorneys to know who their witnesses are and make sure there's the question.
Ladies and gentlemen, these notepads are the only pads that you will take your notes on. No private or personal pad. That's it.
Does everybody have one that needs one? You need a pen? Okay.
Oh, I'm sorry.
Thank you so much, Sheriff. All right, someone would like to call their first witness?
Yes, Your Honor, the Commonwealth calls Abigail Zwerner.
Good morning, ma'am. Please stand right in front of Madam Clerk to be.
Where's the right one?
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Put that on the stand. Watch your step, stepping. It rotates.
You can adjust the chair or microphone. Please answer questions the attorneys may have. You may proceed, Mr. Jacobs.
Good morning.
Good morning.
Could you please tell us your name?
My name is Abigail Zwerner.
Ms. Zwerner, I know we talked about this before, but just as a quick reminder, we're not using the names of any children today,
Yes.
okay? I want to ask you, back in January of 2023, how were you employed at that time?
I was working at Richneck Elementary School.
And what did you do there?
I was a first grade teacher.
And is Richneck Elementary School a school that's here in the city of Newport News?
Yes, it is.
How long had you been teaching as of January 2023?
That was, at that point in time, I had been teaching for 2.5 years.
Okay. So you've told us that you were teaching first graders. Roughly how old are first graders?
Around 6.
And how many students, I'm asking only for a rough estimate, but how many students were in your class roughly?
Around 20, maybe more, maybe less.
Sure. I want to talk to you about one particular student who I've identified as JT. Do you know who I'm talking about?
Yes.
On a couple of days before January 6th, was there an incident with JT in your classroom?
Yes, there was.
Now, JT, was he a student in your class regularly? He was your homeroom student?
Yes, he was.
Okay. And so a couple of days before, what incident happened with JT?
On that Wednesday, the student had gotten a hold of my cell phone and he had slammed it into the ground.
And can you describe, if you remember, just his demeanor or behavior in the moments before that happened, leading up to it?
Mm-hmm. He was defiant.
Objection.
Okay, what's the objection?
His demeanor 2 days before was relevant to what happened on January 6th.
Response.
This, Testimony will reveal that this was reported to Dr. Parker, so it goes to her knowledge.
Overruled, which means you all can consider, you may proceed, Mr. Jenkins.
So I had asked about his demeanor in just the moments that led up to the phone.
Yes, he was being defiant, saying no back to my directions.
Okay. And so how did he get your phone, if you know?
It was our small reading group time, and my phone had ring across the classroom, my school phone. And when I had gone back to my small reading group table, I saw him with my cell phone.
Okay. And what was he doing? Do you remember how he looked at that moment?
Just very defiant, almost kind of a challenging face.
After he broke your phone, do you do something about that for him to try to get a consequence, or what happens?
Yes, I immediately bring him across the hall to my lead teacher, Miss West's classroom.
And do you know what Miss West did from there? If you don't know, that's all right, but if you know.
I recall that I asked her to use her walkie-talkie to ask for help.
Okay. And do you know what, if anything, what happened to JT as a result of him smashing the phone?
No,
Okay. Was he at school the next day?
no,
And then did he come to school on January 6th?
yes.
Okay. I want to talk to you then about January 6th of 2023 then, starting in the morning, maybe lunchtime. Did you have some observations about JT at lunch?
I did.
And before you go on, did you end up reporting those observations to Dr. Parker?
Yes, I did.
Okay. Would you just sort of describe to the jury what it was you saw that you ended up reporting?
Yes. Two things had stuck out to me. At the beginning of lunch in the cafeteria, we were standing in the lunch line, and I was approached by another teacher that the student had threatened to beat up one of her students. And so I...
Objection.
Yes, sir.
Sounds like she is testifying as to something somebody else told her.
Okay, so objection, speculation, your response.
Oh, I heard a hearsay objection. Is it hearsay?
Objection.
So to be sure that it's a hearsay objection, we're not offering this for the truth of the matter asserted. The statement is to show Dr. Parker's knowledge of what was told to her, not whether it's true or not.
Sustained. So I think since we're missing hearsay, I'm not sure what exception it falls under. Do you have an exception?
Well, it wouldn't be hearsay if they're not offering it for its truth. So
Then how's it relevant?
it's relevant because it shows Dr. Parker's knowledge.
Which goes to an element of the case,
Yes.
and therefore it has to be reliable. So what hearsay exception is that? Or what case law do you have? What authority allows that to come in?
Judge, if it is hearsay, if the court's ruling is that it is hearsay, it does not come in.
Okay, and hearsay, so you all cannot consider that. Next question.
Thank you, Judge.
Thank you.
So, Ms. Zwerner, I'll
Yes.
back up a little bit. You mentioned that you were you personally in the cafeteria?
I was.
Okay. And was there anything you personally observed about JT that concerned you?
Yes, I was speaking with a security officer in the cafeteria about something, and at that same time, I witnessed the student was staring her down, very focused on her, and he slowly got up from his seat and ever so slowly approached, still not breaking focus or eye contact at the security officer, and that stuck out to me a lot as well.
Okay. And is it fair to say that you do go to Dr. Parker to report concerns?
I do.
And without telling us what anyone else said, did you relay to her concerns that you had about things you had observed and concerns about that had been told to you by others?
Objection.
I don't know what the objection is.
That would be hearsay also.
Did you observe?
She's reporting what she observed. The report is hearsay. It's out of court statement offered for sure.
Okay, your response, Mr. Jenkins.
I am only offering that she informed Dr. Parker of her concerns and that her concerns were based on both her observations and what others had told her. I am not eliciting what others said to her at all, so it's not hearsay.
Not statement, just the, okay, so, overruled, ask your question again, you may answer.
All right, so Ms. Zwerner, did you eventually go speak to Dr. Parker about your concerns?
I did.
And did those concerns include both your observations and what others had said?
I told
Don't tell us what the others said, but just did your observation, did you report to her the problem?
yes.
Okay, tell us what you reported to Dr. Parker.
Your Honor, I'm going to continue my objections because his question was what she observed and what others said. Now he's going to ask her what you reported, and so she's reporting, sounds like hearsay.
Response.
Judge, she is reporting to Dr. Parker concerns she has based on the totality of things that include what others have said to her. I'm not eliciting what others said to her. I am eliciting what she told Dr. Parker. That is what the testimony is. So this is not hearsay. I am not offering the statement of those individuals at all. Even if I was, I wouldn't be offering it for its truth. I'm offering it for Dr. Parker's reaction to her response. So it is not being offered for its truth. It's being offered for her state of mind.
So I'm going to sustain in part and overrule in part. Again, the hearsay can't come in through the front door. It then cannot come in through the back door by her saying, this is what I told her based upon what other people told me. So she can answer your question as to what she told Dr. Parker based upon her personal knowledge and personal observations, but she cannot relay what she told her based upon what other people told her. So you can proceed that way.
I don't know any other way to ask this, but what did you tell Dr. Parker?
I told her specifically that the student seemed to be off already that day and in a violent mood.
At some point during the course of the day, did anyone suggest to you that that same student, JT, might have a gun?
Yes.
Objection, hearsay.
Okay, objection hearsay and maybe foundation. Your response, Mr. Jenkins.
So first of all, that also is not being offered for its truth. We're not offering it to prove that JT had a firearm. We're offering it to prove that someone informed her of a danger. So it's for her response.
So can you lay a better foundation as to how she would have this knowledge?
Sure. During the course of the day, did you become aware that a child was armed?
Yes.
And is that because someone told you the child was armed?
Yes.
Who told you that?
Our reading specialist, Amy Kovac.
Your Honor, I'm sorry. I was distracted. He asked two questions and I did not know what those questions were. So I want to make sure that I understand what the questions were. So.
Okay, Mr. Jenkins, if you could please repeat, or did you ask your co-counsel?
We were actually talking. So.
Okay, he asked, how did you find out he was armed and who told you?
Okay, objection to say.
Oh, go ahead, Mr. Jenkins.
At that point, what was your state of mind as
I'm
to?
sorry, Your Honor. So that was the question. I did not hear what her response was to that question.
She said Ms. Novak, so. I've got your objections on the record, overruled. Start your question over again, Mr. Jenkins, please. I believe you said, what was your state of mind?
Yes. What was your state of mind as to concerns about that being shared with administration? Were you going to go share?
No, Ms. Kovac went and told administration.
And
Objection to consent.
Continued objection noted, you may proceed.
as to that objection, it is overruled, Judge.
It is overruled, yes,
Thank
you may proceed.
After that point, were you concerned enough to keep a close eye on JT?
Yes.
Tell us about your observations going forward from there.
Specifically, what point in time?
Yeah, so at some point, do you end up, your class goes to recess?
Yes.
Are you there?
Yes.
Okay. What did you observe at that time, if anything, that was concerning?
Yes. I noticed that the student was wearing an oversized jacket with both of his hands in his pockets that remained in his pockets the entire time.
Okay.
And that stuck out to me.
Okay. Did you report that observation to anyone?
I texted Amy Kovac that observation.
Okay. After recess, did there come a time when JT and your whole class and you were back in the classroom?
Yes.
And did you observe anything that concerned you when you're back in the classroom that day?
Yes.
Tell us what you observed back in the classroom that started to concern you.
Specifically,
So did you observe JT doing anything that made you concerned once after recess time and you're in the classroom?
Your Honor, we don't object to leading the witness.
Judge, if I may respond to that.
You may respond.
So a closed-ended question where the witness can answer yes or no is not inherently leading. A leading question is one that suggests one of those two answers is the right answer. I am merely trying to direct the witness to where and when I'm talking about. So in another sense, it's just a preliminary matter. I am not, trying to use it to get a specific answer from her.
Anything further, Mr. Steve?
Yes, Your Honor, and I think he's actually been leading for quite a while.
He has, now, but you didn't object to this one, but this one was leading, so I'm going to allow it overruled. But some previous ones were leading, so we'll try to contain that. Do you, the witness, do you need him to repeat the question?
yes, please.
Okay. I just want you to describe any concerning observations about JT that happened in your classroom after recess,
If any.
if there are any.
Both hands remained in his pocket, his oversized jacket, the entire time.
Was he wearing the jacket in your classroom?
Yes. Did not remove it after recess.
So, Ms. Zwerner, at some point in the day, were you injured?
Yes.
Tell us what immediately precipitated that. Describe it for us.
It came to where I saw at the corner of my eye, my peripheral, the student had. I saw the student looking at me. I looked over. A gun was pointed right at me. He was holding a gun, the student, and it was pointed right at me, and then I was shot.
And where on your body did a bullet strike you if it did?
It went through my left hand and into my chest.
What did you do from there?
I recall the children were getting out of the classroom. Miss West was across the hall. She opened her door and was helping the students. And I went to the office.
At the moment the gun is fired, and I am asking you to estimate how many children were in your classroom.
Didn't you cause speculation?
I'm not asking her to speculate about it. I'm asking her to give us a range that it could have been at the time. She doesn't have to guess, she was there.
Oh, you can answer.
I would estimate, I would say most likely the same as before, but estimate on the lower side, I was missing a couple of students that day. Around 20.
Thank you. You've described the moment where a gun is pointing at you. At that moment, are there any children in your field of vision?
Yes.
You've described that?
It's in, the time is in the middle of class, in the middle of a small reading group. So I have students nearby. I also have students at their desks. I have students very close.
Were there any students that were within inches of JT?
Yes.
Were there any students that were between you and JT?
I don't recall.
Okay. May I have a moment?
Yes, sir.
That's all the questions I have for you now. Please answer any quick questions from the defense counsel.
You may.
So basically, JT was in your class on January 6th, is that correct?
Yes.
You reported that he was a little off the chain, being a little violent that morning, is that correct?
He appeared to be off and seemed to be in a violent mood.
Okay. And you had some contact with Ms. Kovac, is that correct?
Yes.
Okay. And you had contact with Ms. Kovac before you went out to the playground for recess, is that correct?
Yes.
Okay. And on direct, you said that Ms. Kovac told you that JT was on, is that correct?
She told me that the student had told other students that he had brought a gun with him.
That
To
wasn't
school.
your testimony on direct. You said that Ms. Kovac told you that he was on. That was your testimony, is that correct?
Here today?
Yes.
I said that No, I'm sorry if I said that. I was specifically told that he was telling other students that he brought a gun with him to
Right.
school.
So now I'm going to.
I might have heard the question a little differently in my mind.
I know this is the cross-examination, but I'm going to renew my objection to that response because clearly now she's referring to hearsay. And I'm going to ask that her answer to Mr. Jenkins be struck.
Okay, that was somewhat of a response.
Your Honor, this information is being used to show why Ms. Zwerner took the action she did, not being offered for its truth. And hearsay is only hearsay if we're offering it because the statement made is true. So it explains the actions that she took. It is in part a present sense impression if the court is going to rule that it's hearsay, because she's describing a condition that's occurring right now while it is ongoing. And it is being offered to show how they respond to it. Counsel is objecting to me eliciting hearsay and then standing up and eliciting hearsay. And she gave a short answer to me because we were narrowed by the hearsay objection. She was explaining it more fully to counsel now because he asked. So he elicited the hearsay this time. So he can live with that. The rule is that hearsay is an out-of-court statement being offered for its truth. We're not offering any of these statements to prove that JT had a gun. We all know he had a gun. We'll have that testimony. We're offering the statements to establish why these people took the actions that they took. That's it. That's not being offered for truth.
Anything else, Mr. Rogers?
I will submit, Your Honor, it is exactly being offered for its truth. Her statement, which I basically just wanted to clarify her response to his question, she said he was on. And so she wanted to further elaborate. Her elaboration, had she elaborated during the first question, I would have objected. Clearly, hearsay, she's repeating something that somebody else told her, hearsay upon hearsay. It's definitely being offered for its truth because there would be no need to respond if there was not a gun.
So for consistent and clear rulings, again, it came in before, I'm going to allow the statement in. This is a classic example of why we have cross-examination, and all three attorneys are wonderful attorneys who will flush this out for the jury, and we can have an instruction later, again, that it is not for the truth of the matter, but to explain why the person did what they did. So again, you may continue with your cross-examination, and the jury can consider the responses, ultimately the ruling. So your current objection to exclude it based on hearsay is overruled. Please proceed with your cross-examination.
Thank you. So, based on information that you received from Ms. Kovac, you believe that the student was armed, is that correct?
It crossed my mind, yes.
Okay, so it crossed your mind that he had a gun, is that correct?
When I was told what I was told, it was possible.
Okay, so if he was armed, that presented a danger to your students, is that correct?
Yes.
Okay. So you took no action to separate JT from his other classmates, is that correct?
Yes.
And so you allowed him to go out to recess with the understanding that he may have had a gun, is that correct?
Yes.
You could have refused to let him go to recess. You could have removed him from the presence of his other classmates, is that correct?
In hindsight, yes, I could have.
Okay. And then you allowed him to return to your classroom with other students, is that correct?
Yes.
Okay, nothing prevented you from excluding him from the classroom, is that correct?
Yes.
And nothing prevented you from actually taking JT out of the classroom and taking him down to the administrative office, is that correct?
Yes.
Okay, so on Wednesday, JT was being disruptive, and you did take him out of the classroom, is that correct?
Yes.
And you also alerted administration, is that correct?
Personally, no.
Okay, but you took steps to make sure that administration was notified, is that correct?
Personally, no.
You did not take any steps to make? Okay, all right. You would agree that the potential that there's a firearm in the classroom is a lot more serious than JT breaking his cell phone, is that correct?
Yes.
You didn't, once you became concerned, aware of the potential of there being a firearm in JT's possession, you didn't personally let the administration know that I believe that he has a gun, is that correct?
Correct.
Okay. You personally did not call the police, is that correct?
Correct.
You personally didn't ask anyone else to remove JT from the classroom, is that correct?
Correct.
You would admit that the person that has the first responsibility to protect the students in the classroom is you as the teacher, is that correct?
Correct.
And you would admit that you did not take any steps to protect the students from JT, in your words, potentially being armed with a firearm, is that correct?
I would not admit that.
Okay. What action did you take to protect the students from JT having a firearm?
This might cross the rules of hearsay, I'm unsure. But from the knowledge that I had that day, I was aware that she was told by other
I'm
coworkers.
talking about what you did. What
Absolutely.
actions did you take?
Absolutely.
All right, your response is absolutely.
I'm sorry, what was the question? The full question?
Okay. What actions did you personally take to protect the students in the classroom from JT being potentially armed?
I trusted my colleagues.
All right. You're on camera, moment.
You may. And while we're doing so, the juror right under that skylight, if you want to move to the empty seat, you can. I apologize. If you're okay, you can stay. There's nothing I can do about
Thank you. Your Honor.
Okay.
I'll get that.
it. Okay, all right. I just want to let you know if there is an empty seat, if you'd like to move.
But if I may ask, Your Honor, you asked the defendant's counsel to speak a little bit.
Speaking loud, we can do that. Thank you. And you follow the instructions yesterday. If you can't hear, let me know. We can fix that. All right, so Mr. Rogers, you heard that instruction.
I did.
Let's project.
My apologies, I'm a soft talker. So, Your Honor, that's all the questions I have for this.
All right, thank you. Any redirect? Yes, Your Honor.
Just briefly, Ms. Zwerner, while you were at recess, were you observing the student closely?
Yes.
Did you have a belief about someone at that time, while you're at recess, going and reporting the issue?
Objection to leading round.
Okay, response?
I said, did she have a concern? It is a yes or no question. That does not make it leading. I'm not suggesting that the answer would be yes or no. I'm just.
Okay, Mr. T, can you flesh out the objection and what part of the question is leading?
What I heard him ask is, did you have an understanding that someone had gone to speak with Dr. Parker while she was at recess? I mean, I think he's leading the testimony there.
And what was your question again, Mr. Jim?
Did you believe that while you were at recess watching, do you believe that someone was reporting what you were seeing with JT, the concerns about JT.
And that's the question that you're objecting to leading?
Yes, Your Honor, because she has not testified to any such thing, and so he's leading her to, and to actually try to testify, on her behalf.
Okay. Overruled, I'll allow it, but there may be another objection from me because we need to establish foundation for this belief. Okay, but go ahead from now, Mr. Jenkins, I'll give you some leeway.
Have you told someone that there was an incident that should be reported to Dr. Parker?
Hearsay objection.
So,
Okay, and I understand, and Mr. Jenkins is saying, well, how can I lay my foundation if you keep not letting me hearsay? I'll allow it, go ahead, it's not for the truth of the matter asserted, it's to explain the actions of why the person takes the actions that they take. Go ahead, Mr. Jenkins.
Ms. Zwerner, I'm not even asking what you said. I'm merely asking, did you report concerns to another person about JT around the time of recess?
I did directly to Amy Kovac.
Overruled, but go ahead, repeat your answer. So he asked you, did you report, what was your answer?
I did directly to Amy Kovac.
And then did you continue to watch JT?
I did.
What was your understanding of the teacher or faculty member role in the event of an emergency or crisis at that time?
My understanding from it was being brought up to administration. I'm not sure how much what sentence to put that in when
Ms. Zwerner, are you worried right now about the rules of evidence and hearsay?
perhaps.
Okay, I don't want you to worry about that. The judge and the lawyers will worry about that, okay? And you don't have to. All you need to do is give an honest answer. So I'll repeat the question.
Yes, please.
Okay. What was your understanding of a faculty member's role when you learned of a crisis? What was your understanding of what you were supposed to do?
Report it.
Okay, great. Thank you. I don't have anything further.
Recall? Yes, sir.
But it was also your understanding as a faculty member or teacher that you were responsible for the safety of your children. Is that correct?
Yes.
And that if there was a threat of danger to your students, you were supposed to remove that danger or threat from the presence of the student. Is that correct?
Yes.
Anything else with this witness?
No, Your Honor.
All right, and does she need to remain or may she be excused?
Your Honor, we're asking that for all of our witnesses, we're asking they be constructively sequestered, told that they need to not discuss the case with anyone, and potentially be recalled, but to be able to leave the courthouse.
Your position.
We've also, she's understanding from the defense of you guys that she.
Judge, if I may address that.
Okay.
We have many witnesses here. We don't need to keep them here for all 3 or 4 days. I've told all of the witnesses they're subject to being brought back to court, and I have all of their phone numbers. And if Mr. Rogers wants them to come back, I will cooperate and ensure that they are back here, provide any contact information that's needed, but I don't want to keep people here for 4 days. They don't have to be.
Understood. So, counsel agreeing to them remain sequestered, but that they can leave the building and they're on call to be brought back. Your position.
That's fine.
That's fine. Okay. All right. So, Ms. Warner, those are your instructions. You may step down from the witness stand. You may leave the building, but you may not discuss the case until this trial has concluded. And they have your phone number, so they'll call you when they need you to come back. All right. Thank you very much. Okay. And we've been out for about an hour. Can we take maybe a 10-minute break and then we'll start with the next witness?
Yes, sure. Thank you.
Okay. And let me see, it's 10:49. We'll resume at 11 a.m. Thank you all.
Leave your books right there on the floor in front of your chair. you are not taking them back, please do not share any papers out.
Next question, move on.
All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground, is that correct?
Correct,
All right, you said that you didn't visually see him yourself, but you knew he was present, is that correct?
correct,
He was out there with his classmates, is that correct?
correct,
Miss Zwerner, his teacher, was out there, isn't that correct?
correct.
Okay. There was nothing that prevented you or Miss Zwerner on that playground to separate JT from the rest of his classmates, isn't that correct?
No,
So you said that you searched his backpack, is that correct?
correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No,
Okay. So you continued to think that he potentially had a firearm, is that correct?
something, he had some kind of weapon.
When you say some kind of weapon, are we talking?
We're still talking gun because that's what the girls reported. I did not know what was in that bag.
So are you holding out the possibility that it's a toy gun?
I am not sure what it was.
Yes or no?
It could have been, yes.
So if it was a toy gun,
We still report and they still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children, isn't that correct?
If there is a report, it is required by the state that you report.
Do you
And
understand
I
my
did
question?
report. I do understand your question.
Okay, does it?
Okay, hold on, for everybody, we're gonna lower the temperature in the room. So the objection would be non-responsive, because she did not answer your question, she answered a different question. Can you repeat your last question, Mr. Rogers?
Do you believe that a toy gun presents a threat of harm to those students?
It could. Yes, yes, it could.
Okay, explain. How in the world a toy gun could
A
present
BB gun, a water
I
gun,
said,
any kind.
my question was,
She answered the question, what's the next question?
so you consider a BB gun as a toy gun, is that correct?
It's a gun. You report for any type of weapon. I reported.
All right. When just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
Do you think it may have been important to take them down to the office to?
I did the actions that I did in that day and I cannot look in retrospect.
Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to, we just cannot check their body without permission from the administrator.
Okay, so did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay, so let's talk about, you say you're a part of the crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan
Are
that
you?
the district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and if the principal and administration gives me another duty, then I do that.
Okay, but nobody told you, Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom, is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
At what point did the students leave the classroom?
When I was walking in, they were coming out.
So by the time that you took a hold of JT and sat down with them, there were no students in the classroom?
No students in the room.
Can I have a moment?
Okay.
after the firing of the firearm by JT, one of the steps that you took was to call the police. Is that correct?
Once I had a hold of him, yes.
Okay. So that phone was readily available to contact the police?
It was her school office, it was her school phone.
Okay. Were there also walkie-talkies that could be used to communicate with administration?
There is, but I did not have my phone or my walkie because of testing had just finished. And state testing, we cannot have that. So I had none of those.
But you did have the classroom phone that you could have easily called down to the administrative office, isn't that correct?
After the shooting, I did call. It was busy the whole time.
All right. So before then, you took no steps to call the police, is that correct?
Correct.
And okay, so, but you did communicate with administration face to face, is that correct?
Correct.
All right.
Several times.
After the incident, did you have communications with Dr. Parker?
Yes.
Okay. You understood that she was very upset about what the things that occurred on that day, is that correct?
I was, well, first of all, I was in shock that day. I did speak to her. We were considered work friends. So I checked in on her. I asked her if she called her husband. I asked her if I could use her phone to call my husband.
Okay, and you indicated to her that the events that had occurred on that day were unfortunate.
Objection, hearsay.
So don't answer, finish your entire question, and then I will go on with that.
You indicated to her by some communications, by text or in person, that you believe that the events that occurred on that day were not foreseeable. Is that correct?
Okay, and hold on, Pastor, I'm gonna go. Okay, and your objection is what, if you fleshed out a little bit more, Mr. Chambers.
So he's asking about an out-of-court statement offered for the truth of the matter. He's asking about an out-of-court statement that she said to Dr. Parker. So that is yours.
Response.
I'll submit to the court.
Self-sustained. All right, so do not answer. Next question, if any.
Okay. And so just briefly going back to the backpack. So you searched it, didn't find anything that you believe presented a danger. Is that correct?
Not at that time, correct. Yep.
Did you observe at all JT on the playground? Did you observe what he was
No.
wearing? You know, anything
No.
that he may have had in his pockets?
No.
Yeah, I'm gonna check with my co-counsel one more time and then I'll be back.
Yes, sir.
I'm sorry, just want to return to the backpack again. When you asked JT to search, to let you look into his backpack, and he said no, was that alarming to you?
His actions were alarming to me.
Okay.
Words that come out of his mouth, it's hot and cold every day.
So you're saying you didn't take that seriously?
I took it seriously because I reported 3 times to the administrator.
Okay, but not seriously enough to say, let's take JT to the office, or let's get his classmates out of this classroom, because I think that,
Objection asked and answered.
talking about backpack now.
I'll allow it. Go ahead.
So not enough to take JT's classmates out of that room for any potential harm.
I did not know what his next actions would have been at that moment, and to keep the children safe if there was something, because a weapon had been reported and no administrator did actions.
Okay, so you could have taken some steps to keep them safe.
I did, as what I could at that time.
Okay, so that's all you could have done is report it to the administration. You couldn't have taken JT out of the classroom. You couldn't have taken the students out of the classroom.
In retrospect, maybe, but I did what I did.
That's all the questions I have.
Any redirect?
No, Your Honor. Thank you, Ms. Coyle.
And this what the status, in terms of being sequestered, excused?
I would request the same with all of our witnesses. I'm asking that she remain sequestered, but be able to leave. Certainly, she is subject to recall by either party.
I agree.
Okay, so, Ms. Kovac, you are welcome to leave the building, but you are still a sequestered witness, meaning you cannot discuss this case until the trial is over. And it's my understanding the attorneys have your number, so if they need to call you back for subsequent testimony, please be available. All right, thank you, ma'am.
Okay, thank you.
Again, you're welcome to leave or stay, but you can't stay in the room. Okay, we do another witness, got about 20 minutes before the break for lunch. We start with another witness.
Judge, I have one witness that we could do, I think, very.
Okay, who would you like to call, please?
Deputy Blythe.
Blythe?
Blythe, B-L-Y.
Okay, thank you. Sheriff, Deputy Blythe, please. Thank you. All right, good morning, sir. Please stand up and get sworn in.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
All right, please take your witness stand. Watch your step, and you may adjust the chair and microphone.
Good afternoon, sir. Please tell us your name.
My name is Thomas Blythe. I'm a retired deputy from Newport News Sheriff's Office.
And were you working as a deputy on January 6, 2023?
I was.
And on that day, did you have occasion to go to Richneck Elementary School in Newport News?
I did. I responded to a radio call of an active shooter at the school.
All right. And did you go to the school?
Yes.
And what did you do when you arrived?
Pulled up in front of the school. Had Deputy Briggs about a half second behind me. We went to the door, tried to get in, but the intercom wouldn't work at the door. There was nobody to meet us. Everything was locked up. We were joined by a couple of Newport News police officers. All four of us pounding on the windows, yelling, trying to get somebody to open the door for us.
Okay. Did you observe an intercom system of sorts on the door on the outside?
Yeah, there was an intercom on the door. It didn't appear to be working, or at least nobody was answering it.
Okay. Eventually, does someone let you in the door?
After about a minute, it was either, I think it was a janitorial staff,
Okay.
opened the door for us.
And roughly how long were you out there prior to a janitorial staff opening the door?
I think by the body camera, it was about a minute, maybe a minute and a half.
Okay.
Felt like an eternity.
Were you armed and willing to go in
We
and
were in
confront?
full uniform, armed, responding to what we thought was an active shooter.
All right, thank you. I don't have any further questions for you. Please answer any from the defense counsel.
No questions.
Thank you. Does Detective Blythe need to remain?
No, I actually, there's no judge, I think he could be released. Yes, so we would like to release him from
Okay, to confirm defense position.
No objection to him being released.
Okay, so thank you, Detective, for your testimony, and being released means you are welcome to stay in the courtroom or you may leave. Thank you, sir.
Thank you, Your Honor.
All right, next witness.
Judge, my remaining witnesses may take a bit more time than that one. Do you want to?
I would like to start. Yes, please.
Now I'll call Brianna Foster, please.
Brianna Foster, Ms. Foster, please. Good afternoon, please stand in front of me. Be sworn in.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
All right, this one. Watch your step, Stephanie. Your chair swivels.
Okay, and you may adjust the microphone if you need to. Any questions the attorneys may have.
Okay,
Good afternoon.
good afternoon.
Would you please tell us your name?
Brianna Foster.
And Ms. Foster, back in January of 2023, how were you employed?
The Newport News Public Schools as the principal at Richneck.
Okay, I'm going to ask you to speak up a little bit. It can be kind of hard to
Okay.
hear. Did you say that you were did you repeat?
Yes, I was employed with Newport News Public Schools as the principal.
Okay, and what school were you a principal at?
Richneck Elementary.
Okay. Ms. Foster, if you know, had your school at Richneck Elementary adopted a crisis and emergency management plan?
Yes,
And if I were to show you the plan, would you recognize it?
yes.
Okay, Judge, may I approach?
You may.
May I approach?
You may.
Just take a look at that document there, and I'll ask you some questions about it. You don't have to say anything about it.
Kind of getting ahead of this, if they're going to try to find anything out of that document, it's going to be offered for the truth of the matter asserted, and I'm objecting to that document. That's hearsay.
All right. Understood that that's coming, and when it becomes right, I'll be ready to hear the objection.
Ms. Foster, just let me know when you've had enough time to look at that document.
Do you need me to look through it in full or just?
My question is going to be, is that a fair and accurate copy of the Richneck crisis management plan as you remember it?
I cannot answer that in full, that I remember that it's a fair and accurate representation.
Understood, I'll take it back. At the time that you were working on January 6th of 2023, were you aware of the crisis management plan?
Yes, I do recall that we have one.
Okay, and what was the purpose of having a crisis management plan at all?
We're just required to, every school is required to have one.
Okay, was it your intention that you would follow the crisis management plan in a crisis?
That's, yes.
Okay. I want to take your attention then to January 6th of 2023. On that day, was there a crisis incident that occurred at the school?
Yes.
Okay. And what was that in brief?
Later that afternoon, I found out that there was a student, it was reported that a student had a weapon.
Mm-hmm. At any point, was there a critical incident that required police to show up?
Would you mind clarifying what you mean, like how?
Did something huge happen on January 6th of 2023? That's the whole reason we're here? Okay.
Yes.
And what was that?
That a student shot his teacher.
Yes. So I want to ask you, prior to that moment, the moment of the shooting,
yes,
had anyone?
I'm sorry, I'm going to object to her response to the question unless she actually observed the incident. I don't think that she was present when that occurred, so she testified to what she observed. She has made a conclusion that I don't think she can really testify to.
Response.
Judge, it's the incident for which we are here. She's the principal of the school. She knows what happened at the school that day. I'm just trying to orient her in time so that I can ask a question.
Okay, so I'll overrule it and it's received in that posture as to why are you here in court today? The incident that brings you to court today. Not that she observed it or anything further than that without further questions and testimony.
Thank
So
you.
what's your next question?
Prior to that event occurring at your school, did anyone tell you that JT or anyone that there was a weapon on campus?
No.
Any hint from anyone that there was a weapon on your campus prior to that?
No.
Roughly how many students attended Richneck at that time? And I don't mean on that day, but just the total number of students that would have been in the school. And you can give us an estimate.
I truly do not recall, but if I had to give you a number, maybe 500, 500.
I want to talk to you about a student named JT. Are you familiar with who I'm talking about?
Yes.
We're not using any student names at all. So any students that you mentioned, please don't use their name. Had you personally, prior to the incident on January 6th, so earlier that year, had you personally had any issues with JT's behavior that you saw?
Yes.
Objective, relevant, Your Honor.
Okay, and what's the objection? I didn't hear you.
Relevant, Your Honor.
Right. Okay, response?
If she handled a discipline issue with JT that the defendant knows about, then it's relevant, as all of those are.
We've allowed those in previously, so I'll allow this in to be consistent. So you may proceed. You can answer the question. Do you need him to repeat the question?
Yes, please.
So the question was, in the time before, the days before the shooting, had you personally been aware or observed behavior of JT that was a discipline issue?
Yes.
And could you just describe that?
To my memory, earlier that week, there was a situation that took place between him and his first grade teacher involving her cell phone.
Okay, and did that situation come to you?
Yes.
And who appeared to you to
I actually think it was 2 people that came to me. I don't remember if it was his teacher.
Okay.
I'm sitting here trying to think back exactly how I knew about it, but I remember calling his mother that evening.
Okay. So as a result of that incident, you did contact his mother?
Yes.
Okay. Any other specific instances, discipline-wise, of JT that year that you remember? If you don't remember, that's fine to say that.
Not in detail, but there were other incidences that took place.
Okay. If you know, did the school attempt to do anything to try to moderate that behavior?
Yes.
And what was it that the school did to attempt to control behavior?
I don't remember the name of the process that was in place. However, they met, it was a scheduled number of, like, let's say weeks or throughout the month, where they would meet with the teacher, assistant principal, parent, and Ms. Kovac to go over like his progress, academics, behaviors, and come up with the plan, essentially progress monitoring, how he was doing it in school.
Okay. And I just have one last question for you. Is it true that you were working at the school hand in hand with Dr. Ebony Parker?
Yes.
Okay. And is Dr. Parker in the courtroom right now?
Yes.
Okay. Could you please just describe what she's wearing and identify her for the judge or point her out?
Yes. She has brown and black hair. If I'm not mistaken, she has a navy blue.
And does medical recognize she's identified the defendant?
So noted.
Thank you. I have no further questions for you. Please answer any questions at the defense counsel.
Thank you.
Yes.
Good afternoon, how are you?
Good afternoon.
Just a few questions. There was a crisis management plan in place, is that correct?
If to my knowledge, yes.
Yes.
Okay. All right, I'm sorry. So there was a crisis management plan in place, is that correct?
To my knowledge, yes.
Okay. And if there were any type of crisis at the school,
Yes.
had you instructed any of the teachers or staff not to come to you with that crisis?
No.
Okay. Was it the policy of your school for staff members to bring problems to Dr. Parker and if whatever she said goes? Or were you ultimately responsible for the safety of the students at your school?
To my knowledge, it's a joint. In my previous positions, it's hard to say, like, ultimately I am as the principal, yes.
Okay. So would you expect your staff members, if they weren't satisfied with whatever was brought to the assistant principal, that they should bring whatever that crisis or problem to you?
Yes.
Okay. Did that occur on January 6th of 2023?
No.
Could any teacher who had a disruptive student in their class, could they have brought that student to the administrative office?
Yes.
Okay. Would you expect them to bring that student to the administrative office?
Yes.
If any teacher or staff member had the belief that there was a firearm possessed by a student, would you agree that that student should be separated from the rest of his classmates?
Yes.
Would you also agree that law enforcement should be immediately notified?
Yes.
Before the shooting, as far as you know, did any of those steps take place?
To my knowledge, no.
Have a moment, Your Honor?
Yes, sir.
Your Honor, that's all the questions.
Thank you. Any read the rest?
So on January 6th, during that day, what were you doing and where were you in the school?
Do you want a timeline of the whole day?
As much
As
as
much
you
as I-
remember, fair enough. If you don't remember, you can say you don't remember, but just as much as you remember, where were you and what were you doing that day?
That day we had some interviews in the morning. I subbed gave a teacher a break so she could handle lunch for herself, a personal lunchtime.
Now, when you were doing the interviews, where would you have been in the school?
The main office, in my office.
In your office,
Yes.
okay. And then the second thing you said you did was what again?
Relieve the teacher so she could have a lunch break.
So that would have been in a classroom?
Yes.
Okay, then what?
Then I remember we had a family and military life meeting with the new partnership that we were forming
Okay, where did that occur?
in our conference room.
Okay,
And then after that, during that meeting, I remember emailing our lead custodian to ask about, I think I walkie or email our lead custodian, maybe Dr. Parker, asking about space, because they wanted to know about space and I couldn't remember off the top of my head where we could put them. And then after that meeting was over, Dr. Parker and our lead custodian came to my office, in addition to 2 students who were waiting to speak with me, came to my office.
okay. And while you're in your office, what's the first signal you get that something is wrong?
I think the words I heard were, he has a gun, or she's been shot.
Okay.
And then
What did you do?
from there, I slammed my door and I took the 2 students who were in my office and everyone else and I shoved them into the bathroom and tried to barricade them in. I called my direct supervisor and 911 and I remember telling everyone in the bathroom that I'm going out. And I remember someone saying, you can't, I have to. And then when I went out, Ms. Zwerner was on the ground and there were staff. And I remember saying, like, please put the school on lockdown. And Ms. O I looked up and Ms. O said she had already put the school on lockdown.
All right. Thank you. I don't have anything further for you.
Your Honor, I don't have any follow-up.
Thank you. And the status of this witness?
I would ask that she be constructively sequestered and subject to recall.
No objection to that.
So, Ms. Foster, what that means is, they're done with their testimony for now. They may recall you to come back to the witness stand, but you don't have to physically stay in the building.
Okay.
So you may leave the building, just make sure that the contact information you have is good. So if they need to recall you as a witness, they can. You cannot stay in the courtroom.
Okay.
And you cannot discuss the case until it's over.
And does that mean for the remainder of the trial or just today?
For the remainder of this criminal trial, until this trial is concluded, you cannot discuss your testimony. You are a sequestered witness. but we are not going to require you to remain in the witness room. So you can go about your day and be available if we need to call you back. And they'll let you know when your trial is ended in case, so with that, when your sequestration ends.
Okay.
All right,
Thank you.
thank you very much. And at this time, can we break for lunch?
Yes, Sharon.
Yes, ma'am.
All right, and so it is 1:05.
Judge, can we let the witness?
Yeah, well, yeah, come on down, come on down while I'm talking. So we'll break for lunch. Is there any motions that we need to take up? I'm trying to time when the jury should come back.
Nothing.
Not from the defense.
So let's come back at 2:15, which means I need all the jurors to report at the room downstairs, or back here by 2:10. We need all the jurors to come back at 2:10. I'm giving you an hour, and we will resume at 2:15 p.m. Again, jurors, do not discuss the case, do not research the case, and you're welcome to leave the building and or there's food back there in the jury room if you want to stay in the building. Okay, we are in recess. Thank you.
Please stand for the jurors.
If you leave and someone will come up in. Thank you. Court stands in recess.
Good afternoon. Would you please tell us your name?
I'm sorry,
Could you please tell us your name?
LaWanda Sample Rusk.
Thank you, Ms. Sample Rusk. We have a court reporter taking everything down today. Would you mind spelling your last name for us?
SAMPLE-8RUSK.
Thank you. I want to remind you that during your testimony today, we're not saying the names of any children, only using initials if we need to refer to them, including your own grandchildren or children. We'll only use initials or refer to them as your grandchildren. If anything, okay?
Understood.
Let me ask you, Ms. Sample Rusk, on January 6th of 2023, did you go to Richneck Elementary?
Yes, I did.
And what was the reason that you went there?
I went to Richneck to pick up one of my grandsons, who was
Okay.
a first grader there.
And you have how many grandsons that attended Richneck at the time?
2.
Okay. And when you got to Richneck, did you go into the office area?
Yes, I did.
And if you remember, who was in there when you first arrived?
When I entered the office, it was the 2 receptionist secretaries. And there was a student sitting to the right when I got in the office.
Okay. Do you know the names of either of the secretaries?
I believe one was a substitute there because the other was on vacation. I'm not sure, but the other one was there all the time, and she goes by Miss O.
Miss O.
Yes,
Okay.
I think it's Olive. I don't know, but I think it's Olive. Bailey
That's
or
okay.
something like that.
Thank you.
And we always call her Miss O because that's what my boys call her.
Okay. Now, while you were there in the office, did something happen that took you by surprise?
Yes.
Can you just tell us what it was, what you saw happen?
I was in the office for a little lengthy time because I was speaking with the receptionist. We were talking about cruises and different things. I'm sorry.
You can take a minute, take a deep breath. It's all right.
We were talking, and then a employee of the school, I don't know her name, I believe it's Miss Harris, I'm not sure. She ran into the office and she said, she yelled something about a gun or shooting or something like that. So I was still on the side of the counter where I should be as a visitor in the school. The receptionists were still at their desk. But when the teacher ran in, she ran in and went straight to Dr. Parker's office and closed the door.
Okay, so the teacher went into Dr. Parker's office?
Yes, the entrance from the office,
Okay.
because there's an entrance to Dr. Parker's office from the main office.
Understood.
So, and to both the principal and vice principal's offices from the main office.
So after that happens, what's the next thing you see happen right there where you are in the office?
As she ran in and shut the door, we didn't have any information. And then, or I didn't know. I can't recall exactly. I can't recall verbatim, but we found out it was a first grade class.
So you don't need to tell us what you heard, but really, or what you thought was going on, but just describe it visually. Like, what's the next thing that happens in the office where you are?
Miss O jumped up, got on the phone, and she called whatever code they call out to the teachers over the intercom to let them know that there was something going on.
Okay.
I was a little hysterical because when I found out it was a first grade class, I was ready to go down the hall to find out what was going on because that's my kids down there. So
Now, at some point, does another teacher come into the office?
after that, we called the police, everything. Then just as I was wearing a crossbody purse. Just as I took that off and set that and my keys on the counter, I was gonna go down the hall. Before I could get out the door, Miss Zwerner comes into the office and she's holding herself like this. And I see blood on her hand. And so, by that time, when Ms. Werner came into the office, I had gone behind the main desk that we're supposed to be on. I was back there where the employees would have been.
Mhm.
I had stood behind there because I didn't know what was going on. And I took the little boy that was in the office, took him back. I said, look, you need to hide. I said, hide. I said, my name is Miss LaWanda. I got you. I said, you hide. The kid hid so good, I couldn't even find him after I really looked and looked for him. But he was back shoved up under the one of the big copier machines.
So let me ask you a question. So while you were telling him to hide, and where are you when you're telling him to hide?
I went to him. I walked from behind the counter, walked to him, took his hand, let him know. I said, my name is Miss LaWanda. I have a grandson here. I said, you're going to be okay, but I need you to hide until we find out what's going on. And so I made sure he was secure. And then when I didn't see him, but I knew he didn't walk out the office, I knew he was secure.
So at that time, after he got secure, where was Miss Werner, if you know?
So I secured him before Ms. Werner came into the office.
Thank you.
He did not see any of that.
Thank you.
I got him out of the way because I didn't know what was going on. He did not see any of that.
I understand. So let's pick it up from that moment where Miss Werner, he's hidden and Miss Werner comes into the office. What do you see?
Ms. Werner comes into the office and, well, before she came into the office, we locked the office door. After the teacher came in and went into Dr. Parker's office, we locked the door. We didn't know what was going on because I locked the door. I ran and locked the door. Then so when I saw Miss Werner, she came to the door and I had to unlock the door for her. She came in and she was holding herself and she said, I've been shot. She was very pale. And then as she walked into the front office to the right, immediately like side by side with the end of the counter, there was a principal's door. Ms. Werner fell there. Okay, when she fell, I lost it. But I was trying to keep my composure because she fell out. When she went down the wall, there was blood on the wall. So I went to her while the secretaries were doing what they were supposed to do, whatever protocol is. I don't know. I'm not an employee. I cannot speak on that. They were doing whatever they were supposed to do to make everybody aware, get law enforcement there, whatever.
Your Honor, I'm going to object to this testimony. It's not a questioning. We are here again regarding Dr. Parker's actions and inactions on that day. This is beyond the time when Ms. Zwerner had already been shot by JT. I don't see the relevance here.
Dr. Parker's inaction caused exactly this that's being described. This is exactly the same as the prior ruling regarding Ms. Kovac's situation in the classroom. This is the shooting's aftermath, and it is the result of Dr. Parker's willful inaction.
Again, how is that relevant? She's charged with child endangerment, and we're talking about the medical response and the response to the people that see that in the office. Is there still child endangerment happening right now? Is that what you're alleging?
Absolutely. There is a result of the child endangerment. There is a prong of the statute that requires proof that the child was in danger and possibly deadly danger. And we have a grandmother who is shuttling a child to safety in that office as the event is unfolding. This event is entirely precipitated by the child neglect. But for it, none of this would happen.
So let's streamline it, because it's going into narrative where she's just giving a narrative and not answering the question. Can you ask another question, please?
Yes, and if I may just sort of inform the witness, I'm going to need to ask you questions. So just pause with me for a moment and we'll walk through it step by step, okay?
Okay.
At the moment that you have described where Miss Zwerner fell down to the floor, can you tell me at that moment, you've said you were with her, do you know where the office receptionists were?
Yes, she was on the phone. Ms.
Okay.
O was on the phone.
All right. And do you know where Dr. Parker is?
I didn't see Dr. Parker.
Okay. And do you know where the principal, Miss Foster, is?
I didn't see Ms. Foster.
Okay. And so while you're there with Miss Zwerner, and at the time that you let Miss Zwerner into the office, did you see Dr. Parker or Principal Foster?
No.
Okay. And so after you have seen Miss Zwerner slide down to the floor, what's the next person that comes to the office? Who is the next person that comes to the office is not a leading question.
I think technically it is, because it presumes that somebody else does come.
Well,
so can you rephrase it to who was the next person that comes to the office, if any?
did anyone come to the office after that?
I don't remember.
Okay.
I honestly do not remember.
Did you ever see a police officer?
Okay, now I can speak on who came, but as far as the next person, and I want to be very specific with my answers to make sure I am answering this correctly.
Absolutely. Let me ask you a specific question. Did police officers come and attend to Ms. Zwerner?
Yes, there was one officer I remember. I believe he was a sheriff's deputy.
You don't have to tell us any more about it.
Yes.
That's good enough. And at some point, do you find the child who had gone into hiding?
Yes.
Okay. And at some point later that day, are you reunited with your grandchildren?
Yes, I was.
All right, thank you. I don't have any further questions for you. Please answer any questions from defense counsel.
Okay.
Good afternoon, Ms. Sample Rusk.
Hi, good afternoon.
All right. You mentioned that when you were in the office, you heard a teacher, or you saw a teacher go into Dr. Parker's office and close the door, correct? And so you don't have any personal knowledge of anything Dr. Parker said or did at that, before that point,
No.
or after that point, right?
Well, I did see Dr. Parker after the police and everyone got there.
Understood, yes.
Saw her come through the office, and the principal as well. But in reference to Dr. Parker, no, I didn't see anything. I didn't see her at all until the end.
Okay, so you don't know what was going on in the office, right?
I don't know. All I know is she closed that door and stood there and watched us.
Hold on.
The
You said
teacher.
The teacher
The
closed the
teacher
door.
closed the door. I did not see Dr. Parker at all.
Okay, so you don't know what Dr. Parker was doing in her office. You don't know what calls she was making or anything like that, correct?
Correct. That is correct.
Okay. You don't know what instructions she was giving, anything like that, right?
No, I don't.
Okay. Ms. Sample Rusk, is it true that you filed a lawsuit in this courthouse arising from these events on January 6, 2023?
Objection, relevance.
Oh, it definitely,
Okay, well, yeah, you can respond.
okay. It's definitely relevant and it goes toward potential bias, Your Honor.
Okay, that was not relevant.
Well, whether she filed a lawsuit in the suit or not, I don't understand how that's relevant to whether Dr. Parker committed child neglect.
I think the law allows parties to cross-examine on a witness's interest in the case. If you file a lawsuit, she may or may not have an interest in the case. That's proper grounds for cross-examination. So you may proceed. Do you need him to repeat the question?
Yes, please.
Please repeat the question.
Okay. Ms. Sample Rusk, you filed a lawsuit in this courthouse regarding the events of that day, correct?
A lawsuit has not been filed yet.
Okay. Have you made any demands of Ms. Dr. Parker or her attorneys?
I'm not sure I understand that. Have I made any demands of her? I'm not sure. Can you, I don't understand. I want to make sure I answer correctly.
Right. Regarding a potential settlement, or have you made any demands whatsoever of Dr. Parker or her attorneys related to that event, to that day?
I have not, no. And as far as I know, there has not been a lawsuit that has been filed yet.
Yet? Okay. Do you know whether one has been drafted?
No, I do not know that.
Have you retained an attorney?
Yes, I have.
Okay. And is it your understanding that a lawsuit, whether it's been filed or not, would be against Dr. Parker as a defendant?
That is correct.
Okay. And before you came into that office that afternoon, you had no idea of anything that occurred before that point, correct?
That's correct.
No further questions.
Can you read the rest?
No, Your Honor.
Thank you. All right, and the status for this witness?
I would ask them to release her.
Okay, any objection? Oh, so ma'am, that means you are released and you're excused from being a witness. So you may stay in the courtroom if you wish, and you may leave. Thank you very much.
Okay.
And watch yourself as you step in.
Okay.
Tell me what that's called. Kelly Wells.
Madam Clerk, to be sworn.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
All right, please step into the witness stand. There's a step. So watch your step, and you can adjust the chair and microphone.
Thank you.
Okay, please proceed.
Good afternoon. Would you please tell us your name and how you're employed?
Good afternoon. My name is Kelly Wells, KELLYWELLS, and I am a forensic specialist with the Forensic Services Unit of the Newport News Police Department.
And as a forensic services technician with Newport News Police Department, what is your regular job? What do you do?
I respond to major crime scenes to include homicides, aggravated assaults, any death investigation that is unnatural or unexplained, and just anything else that is deemed needing forensics.
And when you get onto a scene, what do you typically do with physical evidence that you find?
Typically, I initially take photographs and then I identify the evidence that I see, and as well as search for additional evidence. And I collect that evidence and will either usually process it for fingerprints or swab it for DNA and potentially send it to the lab at a later time, but it then is secured in our forensic services unit.
How long have you been doing forensics work?
This is my 21st year.
I want to direct your attention to January 6th of 2023. On that day, were you called on to go to Richneck Elementary School?
Yes, I was.
Is that here in Newport News?
Yes, it is.
When you arrived at the school, were you directed to a particular classroom?
I was met by my sergeant at the time, which was Sergeant Ramdahl, and he accompanied me to classroom 11.
All right. And in that classroom, did you look for any evidence?
I did.
In that classroom, did you see a firearm?
I did.
Could you just describe where it was and how it was positioned?
Sure. When I entered the classroom, it's rectangular shaped. To the right is the front of the classroom, so the desks were facing towards that direction. And then to the left, there was a table that was behind in the back corner, behind the student's desk. On the floor by that table, there was a Taurus 9mm firearm on the floor. And then just in front of that, there was a student's desk that had a black and white backpack on the floor. And there was a Win 9mm cartridge case on the floor as well.
Okay. So let's talk about what a cartridge case is, just in case some people may not be familiar with that term.
Sure.
What is a cartridge case?
Lots of times people just generically will refer to ammunition as bullets. But typically bullets, what you're thinking of is a cartridge. And the cartridge, which is ammunition, is comprised of a cartridge case, powder primer, and then a bullet, which is the projectile, all in one creates the cartridge. When the cartridge is loaded into a firearm and the trigger is pulled, the firing pin of the firearm strikes the head stamp of the cartridge, causing an explosion with the primer, causing the bullet to propel down the barrel of the firearm and out. And then the cartridge case that remains is then ejected from the firearm. It usually ejects back into the right.
So you have indicated you found one cartridge case. Where was that?
That was at the desk just in front of the table that was on the back left side. It was on the floor.
All right. And then with respect to the firearm, what did you observe about the firearm itself?
The firearm itself, I noticed initially the slide was back partially. And the slide is the top piece of the firearm. And then I was able to get on the floor and look, and I could see at the opening that there was a cartridge jammed in the top of the firearm.
Okay. And would that have been an unspent cartridge? Could you tell?
Correct. It had not been fired.
Okay. And did you determine whether there were any other unfired rounds or cartridges in the firearm?
Yes, once the firearm was cleared for safety by my sergeant in my presence, we observed, or I observed 6 Win 9mm Luger cartridges and the 7th from the chamber.
Thank you. Ms. Wells, please answer any questions from the defense counsel.
Sure.
Yes, sir. Okay, no questions. All right, the status for this witness.
She remained on call, Your Honor.
Any objection? Okay, so Ms. Wells, you're free to leave the building, which is still sequestered, so you cannot discuss your testimony until you've received information that the case is over.
All right.
Okay, and they have your contact information, they need to call you back.
Yes, Your Honor.
Thank you.
Thank you.
All right, next witness.
Commonwealth calls Jennifer West.
All right, thank you. on in. I get to walk all the way around the front.
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, full truth, and nothing but the truth?
And Ms. West, please enter the witness stand right here. And if you go around the corner, there's a step, watch your step. You can adjust the chair and microphone. Please answer questions the attorneys may have.
Good afternoon.
Hi,
Could you please tell us your name?
Jennifer West.
Ms. West, how are you employed?
I'm a teacher.
I want to take you back to January of 2023. Were you a teacher then as well?
Yes,
What school did you teach at?
Richneck Elementary,
How long have you been a teacher?
23 years.
And what grade did you teach at Richneck back in January 2023?
First grade.
Could you help us understand where, if you know, do you know where Ms. Zwerner's classroom was?
Across the hall from mine.
Okay. Taking you back to that January 6th date in 2023, on that day, based on, for whatever reason, did you end up observing a student named JT while he was at recess?
Yes,
And where was your class at that time?
also at recess.
And while you were observing JT, could you describe, just as if it was a movie that we were watching, just the actions that you observed?
He and another
And
student.
I'm sorry for interrupting you, but I need to at this point because I forgot to remind you, we're not using any names of students. Say a student, or you can use initials, but please don't say the names of any students.
He and another student kept going behind the rock wall, and there's a large tree on the playground. They'd go back there, come back out, and I just was watching their interactions.
Do you know the initials of the other student?
RR.
And do you know the initials of the
JT.
first? Okay. So describe for us what exactly JT and RR were doing in as much detail as you can remember.
It's hard to remember specific details, but I did write down notes the day of, and I reviewed those before coming.
When you reviewed your notes, did that help you refresh your recollection about what happened?
Yes.
Okay, well, then what happened?
They were staying together, very close together. They kept going behind the rock wall, going behind the tree, kind of being secretive, trying to avoid other people.
Okay. I'll agree that the trying to avoid other people part should be stricken.
So sustain, strike that part, trying to avoid other people. But you can consider going behind the rock wall. Next question.
Ms. West, when recess ended, did you have a conversation with RR?
After we got back in the building.
Okay. And before I ask you to tell us what RR said, can you just describe his physical demeanor, how he appeared to you?
So I asked him to come speak with me to ask him about what we had observed at recess.
And before you tell us what he said, I just want to know his demeanor, how he appeared.
He was visibly shaken, nervous. I asked him what they had been doing, and he said,
Okay, hold on. Before you tell us what he said, I'll ask judge and counsel if we need to voir dire this witness. Just hold on just a moment.
Your Honor, I think based on previous rulings, that court will allow her to testify, but we're objecting for the record that any statements that she may have heard from RR are hearsay.
Okay, your continuing exception is noted. Thank you. All right, you may proceed, Mr. Jenkins.
Tell us what RR reported to you.
he first said he couldn't tell me, and I reassured that he could. And he said, I can't. He said that he would hurt us, that he would blow us up. He was referring to JT at the time. And then he said that JT had a gun. And at that time, I asked him what it looked like to kind of confirm whether it was real or not. And he said that he saw the bullets. And I said, well, what color? And he said they were bullet colored. And at that point, he was crying. And I had RR come into my classroom.
And then once RR was in your classroom, did you place a call?
I did. I called the front office.
And what was the purpose of that call?
To report what RR had told me.
Okay. And who answered the phone?
Mr. Sims, our music teacher.
Okay. Thank you. If you could give me just a moment. I want to now fast forward a little bit and jump forward. Later in the day, did some students come running into your classroom?
Yes, I think it was just before 2 o'clock.
Hold on. Can you back up from that for a moment and just walk us through what happened that you observed or heard in the moments before students came into your classroom?
I heard a gunshot and I immediately knew what it was. And I went to my classroom door and opened it. And Abby's students came running out and I ushered them into my classroom. And I could see that Abby was standing. She had just exited her room. And I could tell that her hand was bloody and there was blood on the floor. Once the last student that was on their way out came out, I shut my door and proceeded to lock down, turn off the lights, and settle the students.
In as much detail as you remember, can you describe the behaviors that you observed, the demeanor that you observed of the students as they came in?
They were terrified, many of them crying. RR was situated behind me. I was sitting on the floor with the students around me. And he kept repeating, I told you. I tried to keep you safe. I told you. And I just kept reassuring. There were a few students who were trying to tell me what happened, but I didn't want my class that didn't witness it to hear all of the details. And I just kept reassuring them that we were okay.
Were some of the children were crying?
Yes.
All right. Ms. West, thank you for your testimony. I don't have any more questions for you right now. Please answer any questions from defense counsel.
Yes, sir.
All right. Good afternoon. How are you?
I'm okay.
I understand that you're upset. And, that's reasonable. Whose student was RR? Was that your student?
No, that was Abby's student.
Okay. Did you have a relationship with RR? Or?
I try to have relationships with as many students as I can. So yes.
Okay. And when you had contact with RR after recess, could you tell us again what prompted that?
What I was observing at recess was RR and JT kept going behind the rock wall behind the tree, and I asked him to come tell me what was going on at recess.
Okay. Did you during that recess time, did you believe that JT possessed a firearm?
I was not convinced until I spoke with RR.
Okay. So while the children were out on the recess, you did not feel a sense of danger or imminent harm to the children. Is that correct?
I don't really know how to answer that. We were kind of observing. I had been told that Dr. Parker had been made aware.
All right, I'm going to object to that statement.
Objection to that. If this is a question that he asked, and moreover, just a moment ago, he asked the question, what prompted her to talk to RR? And she's entitled to answer the question that he asks.
And so, again, we don't know what the answer is going to be, and it doesn't make it necessarily admissible. But that is hearsay that she was told. So at this point, we cannot consider that unless it comes in under another exception.
Thank you.
Next question.
So based on your observations of RR, you weren't convinced that he possessed a firearm, is that correct?
I was convinced they were hiding something.
Okay. Had you believed that he possessed a firearm, would you have taken steps to exclude him from the presence of the other students?
I'm not sure how to answer that.
All right, well, I'll ask it a different way. If a student possesses a firearm, should you take steps to exclude them from the presence of other students?
That's the administrator or security's job.
So as a teacher, you don't feel like if a child possesses a gun, you should take steps to ensure the safety of those classrooms?
If a child possesses a gun, I rely on the people whose job it is to check a child. And
I'm not talking about checking. I'm talking about protecting the other students.
I understand that, but it also could be protection of the other students by not exacerbating the situation.
Okay, so you're saying if a student possesses a firearm, it's better to leave that student in the presence of other students so the students won't become exasperated? Is that what you're saying?
No, I'm saying I would contact security and administration, and they will handle the student.
Okay, so you're essentially saying it's not your responsibility to protect the students.
That's not what I'm saying.
What you're saying is you're going to rely on somebody else to protect the students. Is that correct?
Sure.
Okay. All right. Did you have any conversations with Dr. Parker prior to the shooting?
Yes. It was, I don't know that I would call it a conversation. It was an interaction that lasted about 5 seconds.
Did you tell her that you believed that JT possessed a firearm?
No, that was prior to my conversation with RR.
Did you possess any means to communicate with the office while you were out on the playground?
Based on my notes, there was a walkie-talkie. I personally don't remember having it in my possession at recess. I even can't remember what the protocol was that year because they've changed so much. Sometimes there's one walkie-talkie per grade level. At this time, every teacher has a walkie-talkie, but I do not recall specifics of the walkie-talkie that day.
So you don't remember if you had one or if Ms. Zwerner had one?
I do not know.
Okay. Do you remember if anybody, you or her, tried to make an attempt to contact the office while out on the playground?
I did not.
Okay, that's fine. So you didn't observe Dr. Parker's behavior or interactions anytime?
Personally, no.
Can I have a moment here?
Yes, sir.
I'm sorry. So, when I asked you the question about the walkie-talkie, I believe you indicated that when you looked at your notes, you saw that you indicated there was a walkie-talkie.
That I had one after recess. I do not remember the specifics of it before.
What do your notes say?
That I heard Mrs. Kovac on the walkie saying that she had the shooter.
I think that's all the questions I have.
Thank you, sir. Can we redirect?
Yes, sure.
At the time that you hear Ms. Kovac on the walkie-talkie, where are you?
In my classroom with mine and Abby's class.
Thank you. We know, as you testified, you were observing RR and JT at recess. Without telling me anything that anyone said to you, was your reason for observing them based on things you had heard from other faculty?
Yes.
Your Honor. Okay, one moment.
Objection. That we're trying to get hearsay testimony. He's basically asking, did somebody tell you that there was a problem? Just hearsay. He's asking for a response.
I'm not. I'm asking for her reaction to receiving information. This is exactly the same in 100 cases where we have asked a police officer, did you receive information that caused you to go to such and such address?
Okay, but if there was leading, because you were leading her to a particular answer. So can you rephrase? I know it's the same objection based upon leading.
So did you go to recess?
Yes. I was later than normal.
Okay. Was there a reason that you were observing JT and RR?
Yes. 2 teachers told me that they
So Judge, if I don't point the witness to something, that we're going to encounter this. So we can't have it both ways.
Why can't you say without telling me the reason, was there a reason?
Because the last time I tried to phrase the question that way, it was ruled leading. So I will rephrase the question. Ms. West, without telling me anything that anyone told you, what caused you to observe JT and RR at recess?
That was not the question that I stated would be the permissible question. So she's observing them, and I guess you're trying to listen, she's observing them based upon a reason. And then what would be the next question? When she says, I'm observing them based upon something somebody said to me, then what would be the next question?
That's the whole question. If she says I'm observing him based on what someone said to me, I'm done. That's what I'm trying to get out of her. That's it.
Okay, so my question, the proper question is, without telling me what was said to you, what was the reason that why were you observing him?
I think that's what I just said, but the judge has asked the question.
Okay, but yes, you have the question, Ms. West.
Now I'm confused.
Okay. Was there a reason you were observing JT?
Yes.
Okay. And without making this word somebody said, what was the reason?
There was concern that JT had something that he shouldn't have.
Thank you, Judge.
Any recross?
Sure. So based on your observation, you did not conclude that there was a danger to the students from JT. Is that correct?
Not at recess. Okay. It was following recess.
All right. And that your concerns came to fruition after your conversations with RR.
Yes.
Okay. So there was nothing to prevent you from excluding JT from his classmates. Is that correct?
Nothing to prevent me from?
Yeah. You could have, if you perceived that there was a danger, you could have excluded him from his classmates. Is that correct?
But if I suspected what I had been told about, that could have made things worse.
Did you attempt to take RR to the office?
No, I called the office and reported what RR told me.
Did you attempt to take JT to the office?
I did not. My last interaction.
Did you yourself attempt to contact the police about your concerns?
No, I called the office.
That's all the questions I have.
Anything further for this witness?
No, Your Honor.
And status of Ms. West as the witness?
I ask that she remain subject to recall and trial.
Same. So Ms. West, you are still a witness, you are still sequestered, you may not discuss this case until this trial is over. But you do not have to remain in the building, you do not have to remain in the witness room, you are free to go about your daily life. And if you get a phone call that you need to come back to give further testimony, please come back. All right, thank you, ma'am, you may step in.
Thank you.
All right, next witness?
Now, I'm going to ask that we take a break, and there is something that we need to discuss with the court.
All right, and it's been about an hour, which is a good wake up, stretch break after lunch. So we'll ask the jurors kindly to retire to the jury room while we take up a motion.
You have the